the session is live. And this session will be recorded and posted on our YouTube channel for your future reference. Please post your questions on Q&A option available on the top right of the platform. I gladly welcome you all to this interactive, knowledgeable session. I am Karthik, Executive Director of and one of the founding members of BEAM, Bureau for the Empowerment of Arbitration and Mediation, a non-profit organization in Coimbatore, Tamil Nadu. To kickstart, let us get into the objectives of our organization. BEAM. It is well known to each and every one of us that ADR is widely used to resolve disputes in both private and public sectors. Especially during this pandemic, ADR is gaining more attention considering its efficiency towards quicker resolution involving lesser cost when compared to litigation process. Thus, BEAM, a fledgling forum aiming at fostering ADR, constituting the government law college students and budding professionals in Tier 2 cities. The main objectives of our forum are to create awareness among the general public and to provide training to both the legal and allied professionals, to emerge as a bridge between the government law college students and arbitration fraternity in imparting the contemporary knowledge to the students, to regularly conduct continuous professional development sessions for the benefit of government law college students, and to create awareness about the alternative dispute resolution, especially arbitration and mediation, to enable the general public enjoy the benefits of ADR. That includes the micro, small, medium, and enterprises, and the business community overall. To foster institutional arbitration in the Tier 2 cities and beyond, to regularly conduct seminars or webinars for the government law college students and industry professionals, to establish an arbitration institution that is accredited by the proposed Arbitration Council of India, to empower the budding lawyers into efficient arbitration professionals. And thus said, without further delay, let me welcome our moderator, Mr. Ram Subramanian, who is a member of the prestigious Chartered Institute of Arbitrators, UK, and the convener of our forum, Bureau for the Empowerment of Arbitration and Mediation. Welcome, Rams, and the stage is yours.
Thank you, Karthik. Thank you for the wondrous welcome address. Good afternoon, everyone. We welcome everyone on behalf of Forum BEAM to this wonderful session. And we assure you of an engaging session today, as well as valuable takeaways that can be applied directly into your profession as well as career. Well, in India, ADR has a very long history dating back to 18th century or even beyond. Arbitration Act in India has come a long way, starting from 1940 and then 1996, which has evolved up to the latest amendments in 2019. However, when we compare the scenario of the other countries, which has very short history of ADR laws, the development is very staggered or stagnated in India. The main reason being the impediments in the enforcement of the award. That is the topic for today. Among all the stages of the arbitration or any other ADR mechanism, enforcement is the key element. In fact, the whole process is driven towards the enforcement of the award to render swift remedy to the affected stakeholder. To deliberate this key issue of ADR mechanism, today we have two eminent speakers. Our keynote speaker for today, Mr. Francis Xavier, Regional Head, Dispute Resolution at Raja Tem, Singapore LLP. Mr. Francis is already a leading luminary in the field of arbitration in the whole Asia Pacific region, and he needs very little introduction. When we told him about our initiatives to create awareness about ADR, he was very happy, and he assured all his supports. In spite of his busy schedule, He has kindly agreed to share his wisdom among the students and the budding professionals. Our forum and the student fraternity are deeply inspired by your lovely gracious sir. When we thought of the topic enforcement of the arbitral award, we thought it is befitting to learn the nuances from the judge himself. Hence, we have invited Honorable District Judge of Karur, Mr. Christopher. He immediately obliged, considering our initiative to impart contemporary knowledge to the government law college students and budding ADR professionals. Thank you so much for your valuable time and effort, sir. Our presiding speaker for today, Mr. Christopher, he completed his law degree from Government Law College in the year 1995. Later, he practiced as an advocate at Madras High Court up to 2014. Then he joined judicial services in the year 2014. Now he is serving as the district judge for Karur district, Tamil Nadu. During his tenure, Mr. Christopher, he has rendered many important judgments that includes both civil and criminal jurisdictions and also arbitration cases. Without delaying any further, we invite Mr. Christopher, District Judge Karur, to inaugurate a session and share your wisdom, sir. The stage is yours.
Yes, good evening to everybody. First of all, thanks for inviting me to preside and inaugurate this session. It is a good organization instituted for promoting the arbitration, a new concept to the citizens who are residing in second tier of cities. It's a welcome initiative because arbitration as a by name, it is new to our society. That too in the field, in the area where the ordinary citizens are residing. So I thanks for the beam to invite me, particularly Mr. Ram Subramanian, who has introduced me now. Furthermore, I thank Professor and Principal Ms. Durga for introducing me to BEAM by which I got a good contact now. I can explore and also utilize the services of BEAM in future for many other purposes also. So I thanks Ms. Durga for this invitation and introduction to BEAM. Now, I also wish Mr. Francis Xavier, a keynote speaker of this session. I thanks. I have a privilege to hear your useful useful words about the arbitration and enforcement of arbitration award. So, thanks to all of you. Here, as stated by the our convener, Mr. Ram Subramanian, we have a strong history of adjudicatory method, a dispute resolution method, right from the beginning of a civilized society in India and also particularly in Tamil Nadu. We know that there are several history about the dispute resolution in Tamil Nadu. You know Silappadigaram, a great novel about the dispute resolution of a theft done by a king. That is the main agenda. There are several history. There are several history about our adjudicatory method. Now, what is dispute resolution? A dispute resolution is a resolution of a dispute between parties. We know in the common days, that is nowadays, the formal adjudicatory method, that is approaching the court of law for getting a small matter to be adjudicated. Now, that was discussed by various eminent persons. Now they evolved an alternate dispute resolution method. You know that ADR is the one palm part of our judicial system in India. we have introduced section 89 in CPC, that is Civil Procedure Code, that there must be an alternate resolution for every dispute. The court should go through the entire case, and whether it is possible to refer the matter for ADR system, then we have to explore that option also. So now the society has changed from formal adjudicatory method to informal adjudicatory method, that is the alternate dispute resolution method. The Arbitration and Conciliation Act, which has a history for its own, from 1940, it has evolved from 1940 to 1996. Now there are 2 amendments in 2015 and 2019. By this amendment, by this enactment of the Arbitration and Conciliation Act, a new concept was introduced in the judicial dispute resolution method. The arbitration is a new concept to India, but even though we have got so many other methods in our past history, that panchayat and the king come to the street to resolve the dispute between the parties and all those things. Now the arbitration is a codified law which deals with a private dispute between 2 parties, when there was an agreement between them to decide their own disputes arising out of that agreement. So arbitration and conciliation is a new concept to Indian society in the other aspect. So at the beginning, as a young lawyer in 1996, I got some aversion towards this concept of arbitration. What is arbitration? Why a person has to arbitrate a matter which has to be decided by a court of law? Normally, we feel that if a court decides a matter, then it is a good decision. But where a third party, a private party decides a matter, we feel that it is not such a enforceable decision. So we have lesser confidence in the alternate dispute resolutions, particularly in arbitration matters. But now that concept has changed. We have come through various arbitral award which gives a final solution to the dispute between 2 parties. So the arbitration method, the method of arbitration gives various it gives various particularly what I want to say is arbitration is a new method which saves our energy, which saves our money, which saves our time. So it gives some other benefits to the parties to the dispute. So now there is a conceptual change in the minds of the people, but where it lies, from whom, for which people this arbitration is applicable. But here it was not expanded from the cosmos cities. That is the problem. We know in Chennai, Calcutta, New Delhi and Bombay, the people say that we can resolve our dispute through an alternate dispute resolution method. That is, one is arbitration, another is mediation, conciliation, lok adalat and other. But that concept was not so popular in the field, in the area of rural people. Now I am working in a rural area like Karur. It is a small town where it is only a municipality is there. So here, if you say that you go for an alternate resolution, they will say that no, you yourself decide this matter, Your Honor. We don't want to go for an arbitration or for conciliation or mediation. They fear that they will not get justice in that forum. So we have to change the minds of the people that the alternate resolution is another method of adjudicatory process by which we can save time. We can save time. We can save money. We can save our energy also. these are all the benefits of alternate dispute resolution. We have to take this to the people where they fight for a single, fight for a petty issues. They even for a petty issues. Now, as far as Arbitration and Conciliation Act is concerned, it is for the people who are in agreement between them. There was an agreement, there must be an agreement between them. If the agreement says that the dispute arise out of that agreement can be adjudicated through a arbitration, then the matter has to be decided only by an arbitration method, not otherwise. The section 8 of Arbitration and Conciliation Act and section 5 of the Arbitration and Conciliation Act very well says that the intervention of court is very limited where there was a arbitral agreement between the parties. So, as per law, the section 5 and section 8 diminishes the intervention of the court in the matter of arbitration and conciliation. Now, you are all well aware of the arbitral proceedings, how to initiate and how to arbitrate and how to pass an award, all those things, because we are now concerned with only enforcement of arbitration award. As far as this aspect is concerned, you know that part 1 applies to Indian arbitration, that is domestic arbitration. Part 2 deal with international arbitration and enforcement. Here, section 36 deals with enforcement of award. That is, the award passed by a domestic arbitration method. So, section 36, there is no big dispute or quarrel in law how to enforce that domestic award. Whereas a similar word is used in section 49, that is international arbitral award, and also section 58, where the award based on the Geneva Convention, that is part 2 of chapter 2 of part 2 of Arbitration and Conciliation Act. Here, enforcement is concerned, normally award would reach the court after a period of the appeal time. That is, if anybody wants to appeal against the arbitral award under section 34, after that, if the arbitration was appealed or a petition under section 34 was filed before a court of law challenging the award, after the prescribed period, that is the 90 days, after 90 days of that arbitral award came into force, a EP execution petition can be filed before the district court. The district court has to deal with the execution petition as like that of a degree of the court. Here, there is some a conceptual or mind-wise concept that arbitral award is not like a degree of the court because it was not passed by a judge. It is a human concept. It is a human tendency that if a court passes a degree or order that has a higher value than an award of arbitral tribunal. Here, that was not correct. What section 36 says, you simply read the section 36 for your, where the time for making an application to set aside the arbitral award under section 34 has expired or such application have been made, it has been refused, the award shall be enforced under the Code of Civil Procedure 1908 in the same manner. Here the word we have to see, in the same manner as if it were a degree, of a court. Court was defined in CPC and other laws, so it has the value of the degree. But normally the litigants who are cited as respondents, they see that it is an award, not a degree. But Act clearly says that it is a degree passed by a court. So it has to be implemented, it has to be enforced under Order 21 of CPC. CPC Civil Procedure Code Order 21 deals with execution proceedings. How to execute a degree. So there are several provisions. There are this order rule 1 to 106. There are 106 rules there were there to how to implement a award or a degree. Here, the one question arises. One is the jurisdiction of the court where EP has to, the execution petition has to be filed. The first question. Second question, what are the measures that can be taken by the execution court in implementing an award? Second. Third one, whether the applications which can be filed as per order 21 of CPC can be filed in case of award passed by a arbitral tribunal. These are the questions we have to see and analyze that. Furthermore, the section, I think section 2 defines what is court. According to section 2 of Arbitration and Conciliation Act, court means the principal district court. That is the principal court of the district. Would be the court as per Arbitration and Conciliation Act 1996. But there was small variation. The Honorable High Court of Madras Judicature has passed a judgment in 2018 or 19. I could not find out that judgment that says that it need not be, as far as execution proceedings are concerned, it need not be the principal district court. It can be even filed in district municipal court or sub court or district court according to its pecuniary jurisdiction. If your award is for lesser than 1 lakh, it can be very well filed before a district municipal court. And if it is in between 1 lakh and 5 lakhs, then it can be filed before a sub court, that is subordinate judge court, which is in between district court and the municipal court. If it is about 10 lakhs, it can be filed before the district court. So the section 2, which defines that court means principal district court of a district, doesn't apply to execution proceedings, because the word used in the section 36 deals with that. Here it says that the award shall be enforced under the Civil Code of Civil Procedure 1908 in the same manner as if it was a degree of a court. Here, how it has to be interpreted, that enforced under the Code of Civil Procedure. Code of Civil Procedure says that if a degree was passed by the court, it can execute the same. Here, a degree of 1 lakh can be executed by the court of municipal. A degree for 5 lakhs, below 5 lakhs, can be enforced by the court of sub-judge. A degree which was above 10 lakhs can be enforced by the district court. So it denotes only the court, not the principal court, as contemplated under section 2 of the Arbitration and Conciliation Act. So as far as section 36 is concerned, section 36 is concerned, it can be filed, the execution petition can be filed in the court which has pecuniary jurisdiction. So one aspect is very clear, because section 49 says, section 49 is the enforcement of foreign awards. It clarifies that a court means a principal district court. In section 55, section 55 Arbitration and Conciliation Act, the explanation part says, in this section, that is a section which deals with enforcement of foreign awards, which says, specifically says that court means principal civil court of original jurisdiction. But no such explanation is available for section 36. So, by the judgment of our Honorable High Court of Madras, the execution petition of arbitration award can be filed according to the pecuniary jurisdiction of that court. Second aspect of jurisdiction is, the CPC says the jurisdiction with the court which has jurisdiction to deal with a dispute. First of all, if a dispute relates to a immovable property where that property resides. If a dispute relates to a person, then where the defendant is residing. So the jurisdiction, we have to analyze and invoke the jurisdiction where the defendant is residing, or where the property against which you are going to execute the award. So these are the jurisdiction you can invoke by implementing the award. The award can be passed at Calcutta or Madras or even at Delhi, but it can be implemented anywhere in India according to the jurisdiction envisaged under CPC. So territorial jurisdiction also there. Third aspect I wanted to tell about section 47. It is the lawyers in Tamil Nadu, in India very well know that every execution proceedings was stalled for years together by if you invoke section 47. Why? Because every dispute arise between the parties has to be adjudicated in the execution proceedings, not by way of other sort. That is why the section, the wide context of the section 47 is very wide. The people, the advocates taking advantage of that section, they prolonged the execution proceedings, and the person who got degree would not enjoy the degree till his lifetime. So whether the application of 47 is available for enforcing the award is a question before you. Courts in India have stated that not only for award, even for a degree, the question that can be decided in section 47, where one is the executability of the award or a degree, not the legality or validity of the award or degree. So most of the applications filed under section 47 only deals with validity and legality of the award or the degree, but that is not permissible in law and are under section 47, that the award is illegal. You can't say that the award is illegal, or you can't say that the award is invalid in law. So unless you invoke section 34 for saying that the award is illegal or invalidated, then you can't say in section 47 by invoking section 47 of CPC. It's well settled law that the very same principle will apply to arbitration award also. The other provisions, we know that section 50, rule 58, rule 89, 90, 101, 106 and other things. These are all incidental proceedings contemplated in order 21 rule in CPC. But we have the executive court has to see that the person who got an award has got the award implemented by invoking the provisions available to them. So section 47 is not applicable in entirety, and only in respect of enforceability, whether the award can be enforced or not, the little scope is for under section 47 is available to the respondent in those matters. As far as the foreign awards are concerned, it is also executable in India, but there are certain conditions preceding for enforcing foreign awards in India. Those are all the provisions in the Arbitration and Conciliation Act. I think I took little more time of our dear friend Mr. Francis Xavier, who is stalwart in, I think, stalwart in this field. He will spoke all those points. With permission of the chair, I am finishing my small introductory lecture. I glad to inaugurate this webinar in which Mr. Francis Xavier is keynote addressing. Thank you to all. If any mistake, it is my first webinar on international sphere. Okay, any mistake, forgive me. Thank you for all, particularly Mr. Ram Subramaniam for giving this opportunity. Thank you, sir.
Thank you very much, sir. Thank you very much for your excellent deliberation on the evolution of ADR mechanism in India, as well as how it is enforced at the grassroots level. That is what we want to hear.
Yes, sir.
You have presented in a very palatable way to the student fraternity as well as to the professionals. Thank you so much for your time and effort, sir.
Sir, with your permission, shall I leave this meeting because I have some other commitments also.
Okay, sir. Okay, sir. Thank you, sir.
Thank you. Thank you.
Thank you. Now I invite my colleague Taslima Nasreen to take over. Taslima is the executive director of our forum B, and she is also practicing as a junior advocate. Over to you, Taslima.
Good evening, everyone. Ladies and gentlemen, I would like to introduce our keynote speaker, Mr. Francis Xavier. Mr. Francis, as a leading luminary, needs very little introduction. Mr. Francis is a regional head, dispute resolution at Raja and Tan Singapore LLP. He practices in the areas of international and treaty arbitration and cross-border commercial litigation. He specializes in corporate and commercial disputes, especially in the areas of corporate, banking, property, and financial and investment-related claims. Currently, he is nominated as an arbitrator of a Mauritius entity in a bilateral investment treaty exit dispute with the Government of India. Mr. Francis has recently been appointed as the chairman of the Listings Appeals Committee, an independent committee set up by the Singapore Exchange. He is a global president of the Chartered Institute of Arbitrators, UK, and immediate past president at the Inter-Pacific Bar Association. Mr. Francis was recognized in the National Day Awards 2014 by the Singapore Academy of Law for his role as a vice chairman of Committee of Legal Education and Studies. Mr. Francis, it is our privilege to host you, sir. Now the screen is all yours.
Welcome, you, sir. Thank you. Thank you. First of all, good day to Judge Christopher, Moderator Ram, and Taslima. Thank you for the very gracious introductory remarks. Now, I do know from the moderator that quite a number of students are here. So let me sort of give you what I'll do with your leave, moderator, that I will give a broad overview of what are the issues that arise when you want to enforce an international arbitration award. And then I'll be happy to take questions, right? Now, so the very first starting point is that you are at a stage of the arbitration where you've gotten an award. At the seat of the arbitration, it could be India, it could be Singapore, it could be Vietnam, it could be anywhere. So you've gotten an award. And now what you want to do, you want to translate a piece of paper into money. You want to enforce the award. Now you have two options. As the person who's won the arbitration and obtained the award, you can enforce the award in the seat where the arbitration took place, or you can enforce the award in some other country outside the seat, anywhere in the world. Now, where you will enforce the award, we all know, will depend on where the losing party has their assets. Very simple, right? If the losing party has a building in Iceland, you will go to Iceland to enforce your award against him. So it all depends on where the money is, right? And of course, if he's got a building in Iceland and say you obtain an award in India against the losing party, and the losing party has a building, office building in Iceland and a very expensive villa in Hawaii, then you could enforce simultaneously in both Iceland and in Hawaii, in the US, right? Wherever the money is, you can enforce. Now, once an award is issued, The losing party, I was on mute. Once the winning party obtains an award, the losing party can attack the award at the seat, right? So because we are talking about enforcement, there are two things, right? The winning party wants to enforce the award. The losing party wants to fight the award. So once the award is issued, now in a court order, the court order, you can appeal to a higher court. Arbitration, you can't appeal. There's no appeal. And so there are very, very limited grounds to attack an award. So if the arbitrator or arbitrators made a mistake of law, they got the law wrong. Say the proper law of the contract is English law, and they got it wrong. You can't do anything about it. If the arbitrators got the facts wrong, right? Everyone agrees the dispute is about a car that was driven badly or a defective car that was delivered, but the arbitrators got the fact wrong and assumed it was a lorry, that was delivered wrongly. You still can't challenge it. So the arbitrators can get the facts wrong, the arbitrators can get the law wrong, and indeed, the arbitrators can get both the facts and the law wrong, right? You still can't challenge the award. You can only challenge the award on very, very narrow grounds. I'll come to it in a short while. So coming back, right? Winning party has got an award. The losing party wants to fight the award. The first thing that happens is the losing party needs to apply to set aside the award in the seat where the award was issued, right? And under the model law principles, you have 3 months. The losing party has 3 months to apply to set aside the award at the seat. And most countries, without exception, as far as I'm aware, if you miss the 3 months, there is no scope or room for an extension of time. Usually in a national court, you have 30 days to file an appeal to the higher court. If you miss the 30 days, you still can apply to extend time if you have very good reason. I was on a ventilator in a hospital and I didn't even know that the decree of court had been passed. So the court is likely to give you an extension. But to set aside the award, under the model law principles, there is no extension. It's 3 months and that's it, right? So now, in order to set aside the award, like I said, you cannot argue that the arbitrator or arbitrators got the facts or the law wrong. What are the grounds? So what I'm going to do is I'm going to flash some PowerPoints. So the moderator, please feel free to circulate it, as you wish. But let me, because it's got 6 major grounds, and I thought it's easier. Could you go to the next slide? Okay, second slide, please. Right. So now let me just tell you, the grounds to set aside an award is provided for under Article 34 of the model law, right? So Article 34 of the model law provides when you can set aside the award. Now the model law is a template for national legislation which is promulgated by the United Nations Commission on International Trade Law, UNCITRAL, right? And so most countries which are parties to the New York Convention would have incorporated this model law into their national law. So, like I said, there is an award and the losing party wants to set aside the award. There are 6 grounds to set this aside, all right? Now, well, there are more than 6, but 6 main grounds and then the general ground of public policy, right? So you can say there are 7 7 grounds. So first, party incapacity, the losing party was 17 years old at the time the contract was entered into. He didn't have capacity. The arbitration agreement is not valid. It's invalid either at the seat or under the law of the arbitration agreement. Third, the losing party had no notice of the proceedings. He didn't even know there was an arbitration going on. He didn't know, nobody served him any papers. Or alternatively, even though he knew there was an arbitration going on and he took part, but the arbitrator didn't allow him to present his case. So there was no natural justice, right? No ability to have his case presented. So next point, dispute is not within the arbitration submission, right? So the arbitration clause says, if I bought a car from you, the arbitration clause says, if the car is defective, that dispute, we can go to arbitration, but not otherwise. And say there is a dispute about the price of the car, and there is no issue of the car being defective. So that arguably is not arbitrable, because you can only, according to the arbitration clause, you can only arbitrate disputes about defects in the car, not any other dispute. So one could say the dispute is not within the arbitration submission. Next point, composition of arbitral panel is wrong. I agree. In the arbitration clause, it says 3 arbitrators, but there was only 1 in this case. So the award is not enforceable. The dispute is not arbitrable, right? So this depends on the national law. For instance, in most countries, if you have a marital dispute between husband and wife, you cannot go to arbitration. In some European countries, you can, but generally in Asia, you can't, right? So the dispute is not arbitrable. And the last is public policy, right? Maybe the award was procured by fraud or for some other reason, for public policy or reasons of unfairness, the award will not be enforced. So that really are the grounds to set aside the award. Now, these grounds are found in the model law. They will be adopted by national legislation of countries that are parties to the 1958 New York Convention. Right, so the 1958 New York Convention, as you know, was designed to achieve 2 things. The first is to recognize and enforce arbitration agreements. So an agreement in writing between 2 parties where they've agreed that if there's a dispute, we don't go to court, but we go to arbitration. So the 1958 New York Convention mandates that such agreements must be recognized and enforced. The second thing that the convention does is that arbitral awards resulting from arbitrations will similarly be recognized and enforced. And today, across the world, there are 166 countries which have signed on to the New York Convention. The 166th country, very recently, Sierra Leone, signed the New York Convention, ratified it, right? So those are the grounds for setting aside. So like I've said, I started off by saying the winning party has an award. What can the losing party do? Within 3 months, apply to set aside the award if one of these grounds are satisfied. And Article 34 of the model law says, even if one of these grounds are satisfied, first of all, if none of these grounds are satisfied, you can't come within the 7 grounds, then the award will not be set aside. But more importantly, even if one of these grounds is satisfied, it doesn't mean the award will be automatically set aside. There's a discretion. The court still needs to be told what is the prejudice. Even though there's a mistake, there may be no prejudice. Even though there's a mistake, one of these grounds are satisfied, but there is no prejudice, the court may not set it aside. So even though one of the grounds are satisfied, it may not be set aside. It may be, it depends on the facts of the case. All right. Now, the losing party to an award actually has 2 arrows in his bow, right? So a winning party gets an award. The losing party has got 2 arrows. The first arrow I've just explained, which is that he could apply at the seat to set aside the award, right? But even if he chooses not to do that, he has a second arrow to his bow, right? And what is that? So, can you go to the next one? Next slide. Okay, the next slide is right. While my technical guy is helping me out with that. Now, so you remember this, right? There's an award which is created in the seat. So let's say I had an arbitration with you and I got an award against you, right? You're the losing party. So you have 3 months to set aside the award. But having gotten an award in India, it may well be that you don't have any assets in India, right? You have a commercial building in Iceland. So what I will do is I will take this award and take it to Iceland to enforce it, right? Now, if Iceland is a convention country, if Iceland is a convention country, they will have laws, the model law will be part of their law, right? And so when I seek to enforce the award in Iceland, Article 36 of the model law will apply, right? Which sets out when a court will enforce an award, right? So that is governed by Article 36 of the model law, which says if certain grounds are satisfied, then the court will enforce the award. Now, Article 36 of the model law is very similar to Article 34, right? For some reason, my technical guy is having difficulty. Can you flash that? Right? Now, so under Article 36 of the model law, the same 7 grounds are there, right? So I will go to Iceland with this award, right? And I will seek to enforce it. You, the losing party, can appear in Iceland and say, please, I want to resist enforcement. Do not enforce this award, right? And that is governed by Article 36 of the model law. The same, 6 plus public policy, so let's say 7 grounds. The same 7 grounds are set out in Article 36. So if the arbitral composition, the tribunal composition is wrong, you, the losing party, can go to Iceland and say, hello, by the way, the composition of the arbitral tribunal was wrong. I'm supposed to have 3 arbitrators, we only had 1. So I'm prejudiced because 3 arbitrators may have decided differently the case. I might have won the case. So again, the court may refuse enforcement. If any of the grounds are not satisfied, the court will enforce it. Even if any of the grounds are satisfied, the same principles apply. There is a discretion. The court could say there is no prejudice, I'm not satisfied that there is prejudice because I don't think three arbitrators would have decided differently because, the case is open and shut. It's so straightforward. You would have lost whether there were 1 or 3 arbitrators. So the court may still enforce it even if one of the grounds is satisfied, right? Now, there is one additional ground. So now there is an 8th ground why a court will not enforce the award. That is, if the award has been set aside or has been suspended, right? So if you go to say you go to the Indian court and you set aside the award, you succeed in setting aside the award. I then go to Iceland to enforce the award which has been set aside. The Iceland court has a discretion to not enforce the award because it has been set aside at the seat, but it's not automatic, right? It has a discretion to not enforce it, right? So there is an 8th ground, right? If the award has been set aside or suspended at the seat, right? Now, so the enforcement in Iceland could also be stayed. So the Icelandic court could say, okay, you have filed an application to enforce. I'm going to stay the application because the losing party has filed an application to set aside the award in India. I want to wait and see what happens in India before I decide whether to enforce or not. So that's the stay of enforcement, all right? Now, Now, coming back, right, I want to say this. So the winning party has got an award. The losing party has got two arrows to his bow. First arrow is he could apply to set aside the award in the seat, but he can decide not to do that. Even if he doesn't do that, he can sit back, right, and not apply to set it aside, and then wait to see where you will enforce your award, right? And then you show up in Iceland, right? Maybe 6 months later, you show up in Iceland to enforce the award against him. He will then appear in the Icelandic courts through a lawyer, and he will say, I want to fight the enforcement, right? So even though he did not apply to set aside the award, he is entitled to fire his second arrow, which is an independent arrow to resist enforcement, right? I hope you follow this. Now, or he could do both. He could apply to set aside that, and shoot off that arrow and resist enforcement. He could do both, right? Now, an interesting question comes up, right? Let's say the award is issued in the seat in India. He doesn't apply to set it aside. And then me, the winning party, then proceeds to an Indian court to enforce the award. So now the 3 months is up, right? So he can't apply to set it aside. Can the losing party apply to resist enforcement in India? Because we are not talking about a third country, we are talking about India. Award issued in India, Indian-based international award. You didn't apply to set it aside. Do you have the right to resist enforcement in India? The correct answer should be yes, right? So this principle that the two arrows are separate, parallel and distinct, and alternative remedies has been recognized in many, many jurisdictions, including Singapore. And the correct answer is that even though you didn't apply to set it aside, you can apply to resist enforcement, all right? So that is something that is very useful that you need to bear in mind. Now, so I'm done with the two arrows, so you can stop the sharing, because so long as I'm sharing, I can't see anybody's faces. So the two arrows I'm done. Now, I want to talk about just my last wrap-up points, right? Now, there are some current issues across the globe. So the first issue is, when a person seeks to enforce an award in a third country, so say the award is issued in Singapore, and the winning party takes the award and goes to Germany to enforce the award, and the losing party has already set aside the award in Singapore, the seat, should the German court enforce the award? Now, to us in the common law, the answer seems quite straightforward, right? If the award has been set aside in the seat, no court should have any business enforcing it. But there is a divergence in opinion across the globe. So there are countries which will enforce arbitration awards set aside at the seat. And you remember this, right? When I read to you Article 36 of the model law, it said may. It didn't say if the award is set aside, you must set it aside, or you must refuse enforcement. It says you may, right? So based on that, the French courts in cases like Hill Martin and many other cases have said, even if the award is set aside in the seat, we, the French court, have the liberty and have the power to enforce it. So there are other countries that think like France, Belgium, Austria, and other countries like Poland, and so on. Many other countries like Singapore, US, UK, Germany will not enforce awards set aside at the seat. But just bear in mind that there are countries that will enforce awards set aside at the seat. So, in the UCOS case, more than $1 billion award against the Russian government, which was issued by the Dutch seated tribunal, the losing party, the winning party, even though the award was set aside, went to Belgium to enforce it, where the Russians had a lot of assets in Belgium. And the Belgian courts were not troubled by the fact that the award has been set aside in the Netherlands, because they believe that they can enforce an award which has been set aside in the seat, right? So that is a big issue across the globe. The world does not think in one direction on this issue. Should you enforce an award set aside at the seat? Now, the second main problem that we have, lack of uniformity that we have across the world, is because now we've gone through the 7 grounds and the 8 grounds under Article 34 and Article 36 of the model law. So let's take the last one of the grounds, public policy. Different national courts interpret public policy very differently. You know, most national courts will interpret public policy as international public policy, which should be the right interpretation. But for many years, and even now, many national courts interpret public policy from a national perspective, from their own perspective, which may vary from the international sense of public policy for the purposes of Article 34 or Article 36. So what you have is, you have a public policy test, but which is applied differently in different countries in the world. So you have, if you have an award, you go to country A to enforce it, it may not be enforced. Country B, it is enforced, and so on. So you have a lack of symmetry, a lack of uniformity in the way that the Article 34 and Article 36 tests are applied in principle, right? So we have a lack of divergence in the world, in international practice of the national courts, and this poses a problem, all right? So, Mr. Moderator, sir, I think my aim was to give an overview of the overarching principles or issues that crop up in this area in the enforcement of international awards. I want to just say one last point before I hand it back to you, Ram, which is that so countries which adopt their own definition of public policy will be seen as states which are not arbitration friendly. So for instance, for many years, even India was seen as not being very arbitration friendly because of the way you define public policy. A court was very willing to intervene. But today, of course, India is very, very pro-arbitration. Things have changed. But across Asia, there are many countries which are still seen as not being pro-arbitration because of the way the courts interpret the rules, right? And so, so because of that, they may attract less foreign direct investment into their countries because of that, because there's less confidence in the way the court, the stance of the courts. The courts may be seen as not being sufficiently supportive of international arbitration. Back to you, moderator, sir.
Thank you, Mr. Francis. So you have managed to put across swiftly about the enforcement scenario in the international spectrum in a very palatable way to the students. Thank you so much. So before we move on, there are a couple of questions from the audience. So with your permission, I want to read out. One is Mr. Rajendran Chinkaravelu. So he has asked, how does a party to the arbitration protects his interest against collusion between arbitrator and the other party?
Now, this is a big problem, right? Because anyone can be appointed an arbitrator, right? In a dispute, you and the other side can decide to appoint your neighbor as the arbitrator. And unless the arbitration clause stipulates that there must be particular, he has to be an engineer or a degree holder, technically you could both agree to appoint your neighbor's mate as the arbitrator, right? So long as the person is more than 21 years old, right? And so we do face problems because maybe the arbitrator is not neutral, actually, and even though there's a conflict, you don't know, and the arbitrator doesn't disclose it. We've, across the world, when parties choose arbitrators or have a mechanism for choice of arbitrators, which is not a rigorous, method of choosing an arbitrator, a rigorous method would be to say the arbitrator, if the parties can't agree, will be chosen by the Mumbai Center of International Arbitration, for instance, or will be chosen by BEAM, that would be a rigorous method. But if you agree to a method which will end up with your neighbor's mate being chosen, that's not rigorous. But unfortunately, you agree to it. And so if you end up with problems, because there's collusion and all that, who do you have to blame? You have yourself to blame. Because you chose a imperfect or a defective method of choosing an arbitrator. Now, having adopted an imperfect method, if you land up with that problem and you suspect they're having a collusion, if you challenge the arbitrator, you'll have to prove that collusion, and that collusion may be very difficult to prove, right? But that's where you are. So the panacea or the remedy to this problem is be very careful on how you select arbitrators and who you select as arbitrator. You're on mute, Ram.
Sorry, I hope I'm audible now. Yeah, okay. Thank you, Mr. Francis. Yeah. So the next question is from Mr. Partha. So he is asking, if the losing party uses the second arrow, which you have just mentioned, that is resist the enforcement, whether the entire dispute will be heard once again by the court.
Now, remember this, I told you, when you resist enforcement or you try to set it aside, you cannot say the decision is wrong. The arbitrator got the facts wrong, or the arbitrator got the law wrong. It doesn't matter. The arbitrator could have got the law and the facts wrong. He had a quarrel with his wife, he didn't get enough sleep, so he got everything wrong, the facts and the law wrong. It doesn't matter. You can't set it aside or you can't resist enforcement. If, while you were presenting your final arguments, he fell asleep for 20 minutes, then you can set it aside because you are unable to present your case. He was asleep. But if he was wide awake and he was looking at you, but actually he was thinking about the way his wife scolded him, too bad. Right? So you can only set it aside or resist enforcement under one of those grounds. So you can't rehear the case. The composition of the arbitral tribunal is wrong. That's nothing to do with the case. That is, what does your clause say? Whether the person has capacity, is he more than 21 years? Nothing to do with the merits. You can't go back and re-argue the case at that stage.
Right. Okay, thank you. And next, I have a question to ask from you, Mr. Francis. It's about the New York Convention. You have just elaborated. So how about the non-New York Convention award? The enforcement.
Right. So, if any of the things I've spoken about happens in a non-New York Convention country, then all the principles I talk about may or may not apply. It all depends on the domestic law of the country. So let's say, you are in an African country that is not part of the New York Convention.
Yeah.
I don't know, South Sudan, let's say, right? I was there 2 years ago. Yeah, just fighting and all that, a lot of smoke. So if you're in South Sudan and you have a clause that says have your arbitration in South Sudan, you have an arbitration, you have an award, and you're the losing party, you want to set it aside. None of the principles will apply. I don't know. You have to go to a South Sudan lawyer and ask him, on what grounds under South Sudan law can I set it aside? New York Convention principles may apply because some countries like Taiwan, even though they are not party to the New York Convention, have adopted the New York Convention principles in their Taiwanese Act, right? So even though it's not a New York Convention country, the same 7 factors applies under Taiwanese law, right? So if you're in a non-New York Convention country, it all depends on what the legislation of the country says. Same thing with resisting enforcement. How can you resist enforcement in South Sudan? I don't know. If it's not a New York Convention country, you will have to ask a South Sudan lawyer, under South Sudan law, South Sudanese law, what is the position? Because all the principles that I spoke about may or may not apply. It depends on what South Sudanese law says. Very good question, Ram. It's a matter I should have covered, but I left it out.
So therefore, it is better to see whether the country is New York Convention country or not, isn't it, before entering into any agreement?
Right. But you see, sometimes you don't have a choice, right, Ram?
Right. Yes.
You are contracting with a party who's a South Sudanese national, and his assets are only, in South Sudan, at Sos Yubu, at the border of, the neighboring country. So you have no choice because ultimately, if you get an award against him, Ram, you have to go to South Sudan to enforce because that's his only asset.
Right.
But then you might decide, I'd rather not enter into a contract with him. Because if I have to go to South Sudan,
Yeah.
I may not get my money back because it's not a New York Convention country, and the laws there are quite, strange. I'm not comfortable, so I will not enter into this contract. But you're right. It all depends on commercial factors.
Right. Yeah. Thank you. Next question is from an attendee. His name is Mr. Shyam. So he's asking, when the losing party loses the case of setting aside in the court, can they still resist enforcement based on the same grounds taken in setting aside?
That is an excellent question, right? So I like the way this person is thinking. Yes, because this is what we need in international arbitration, a lot of creativity. And it's true. Don't forget, because I've got two different arrows. If I shoot an arrow once, I try to set it aside and I've lost, right? So let's take a situation, right? Ram and I have a dispute. Ram wins and gets an award in India. The seat is in India. So I'm the losing party. I shoot off my first arrow. I try to set it aside in India. I fail. I appeal. I fail, right? Finished. Ram then seeks to enforce it in Singapore against me, because in Singapore I have a bungalow, right? I still have a second arrow. So the law says it independent. So I can restart the whole case. And you know why? I've told you, different national courts look at issues differently. The Singapore court may have a different perspective to public policy than the Indian court. Yeah, but there is always the argument of re judicata, right?
Yeah.
Because when I raise the same argument I tried in India, in Singapore, you, Ram, will say to the court, Your Honours, this argument is the same argument, and he lost it. So it's re judicata, issue estoppel. What is my learned friend talking about? All right? But I can tell the court, you see, I lost that case because the Indian court in that part of India interpreted Article 34 of the model law in this way, but the Singapore interpretation is very different. So on public policy grounds, you shouldn't listen to the Indian court because you have a different test. You understand?
Yes.
So then, it's not so clear whether you will win or... So the answer is, yes, you can make that argument. But let me give you this scenario. After I apply to set aside Ram's award in India, Ram seeks to enforce it in India because he realized I got a Chinna Vidu in Chennai. And he goes after that. By the way, I'm single, but I won't have that problem. But in case, hypothetical. So, if I then run the same argument before another Indian court, do you think I'm going to succeed? It's going to be very uphill, right? It's going to be tough, right? Because one Indian court is not going to, and I don't have the argument that, in India, there's one test. There's one way of looking at it. But you're entirely right. If I go to Belgium or I go to Germany, they all look at it very differently. Civil law countries and common law countries have a very different perspective. Very good question. Answer is yes, you can do it again.
All right. Thank you. So Francis, you just elaborated the 6 grounds for setting aside. And one of the grounds is non-arbitrable issues. So can you throw some light on that for the benefit of students?
All right. So non-arbitrability means, there are some disputes you cannot arbitrate. So if I am an owner of a provision shop, and in my invoice, I say that if there's any issue between me and you, we will arbitrate. And then what happens is that you came into my shop and you bought, some items. But what you did, there were some items you kept in your back pocket, you didn't pay for it. And then I found out you got caught, right? As you were leaving, you got caught. So you've committed a criminal offense. But I say to you, I don't care. I'm not going to file a police report. I'm going to take you to arbitration because there is this clause in my invoice which says if there's any dispute arising out of this, your attempted purchase or whatever. But you see, that issue won't be arbitrable because whether or not a criminal offense has been committed, whether theft has been committed, that is not arbitrable in many countries. In India, in Singapore, a criminal dispute whether or not a dispute as to whether a criminal act has been committed, it's not arbitrable. It's not arbitrable unless you have a similar, maybe like a civil action of deceit, right? But if it's a pure criminal law issue or a family law issue, husband and wife cannot sign a prenuptial saying, if you have any disputes and we are going to divorce each other, we will go to arbitration to decide whether we should divorce each other, or the division of matrimonial assets will be decided by the arbitrator. In India, that will not be upheld, right, Ram?
True, yes.
It will not be upheld. So, what issues are arbitrable? If you want to make somebody a bankrupt, again, that's not for an arbitrator. But different countries have different laws, right? So in India, criminal conduct is not arbitrable. Matrimonial dispute is not arbitrable. Insolvency issues are not arbitrable. But in Europe, I can tell you there are many countries where matrimonial issues are arbitrable and many insolvency issues are arbitrable. So whether an issue is arbitrable depends on the national laws of each country. And so you're quite right. This adds a third aspect of lack of uniformity across the globe. I talked about two, whether awards set aside at the seat can be enforced. The world doesn't agree, right? How you interpret the various grounds in Articles 34 and 36 of the model law, the world doesn't agree. And this is a third lack of uniformity. What disputes are arbitrable and what are not?
Right. Okay. Thank you, Mr. Francis. I think we are running short of time. So the next question will be from my colleague, Taslima. She wants to ask a question. Taslima, over to you.
Good evening, sir. Sir, there is a question from Mr. Chandran. Is there any way a party can force the arbitrator, allegedly in collusion with the other party, to be honest to the facts and law? That is, can we define some process requirements for the arbitrator to follow as a part of the arbitration clause?
No, it will be very difficult because at the end of the day, Taslima, the arbitrator has the power. He's like a judge, right? He will listen to both of you and then he will come out in an award. You're right, you're wrong. There's no way you can control it by way of an arbitration clause. I can't see how you can prevent collusion through an arbitration clause other than making sure that the the method of appointing the arbitrator is, the responsibility of a reliable third party. If your process of appointment of arbitrator is so defective that you've landed up with an arbitrator who is actually not independent, or he's partial, he's not impartial, then your only remedy is to remove him. But to remove him, you need to prove that there's a conflict of interest under the IBA rules, for instance, or that he's actually not independent, he's colluding. But you have to prove it. And so that will be very difficult.
Thank you, sir.
So as I said, the solution is make sure that the appointment method is good.
Thank you, sir. So now we come to the end of the session. I invite Soundarya to propose a vote of thanks. And Soundarya is one of the founding members of a Forum B and an executive director. Over to you, Soundarya, for vote of thanks.
Thank you, Taslima. Good evening, everyone here. I, Soundarya, on behalf of the Executive Committee and the entire fraternity of the institution. First of all, I extend my most sincere thanks to the Almighty God for making today's event a resounding success. On behalf of BEAM, I extend my hearty vote of thanks to our keynote speakers, Mr. N. Christopher and Mr. Francis Xavier, for giving an excellent coverage to the enforcement of Arbitral Award. My gratitude to the speaker for sharing their opinion today, who spared time from his busy schedule to raise the occasion. Your thoughts have enlightened our world and shown us a new path. We are all inspired by your great words, sir. Thank you. I need to mention my deepest sense of appreciation. I also extend my thanks to all the participants for your enormous cooperation. Last but not least, a big thank you to each one of you who made this event successful. And we are glad to announce our next webinar on 17th November on the topic legal drafting. We will share the link very soon. Thank you so much.
Thank you very much, Mr. Christopher. Mr. Francis, and we'll meet soon in the next webinar. Thank you so much.
Thank you, Mr. Francis.
Thank you, Karthikeyan.
Thank you.